Let's talk about writing a contract for your services. You should explain in that contract what services you offer and your fees for them. I use a simple one-page combination of contract and fee schedule that I've included as an appendix. This contract defines the terms of our agreement and also handles any disputes. Feel free to use it and change it with your name and information. Preferably, have the attorney sign it for his law firm along with the client or case name. You can expect that a law firm that signs a contract with you is more likely to pay you than an unknown client. If your retention is for the defense or in a case involving criminal conduct, you should definitely sign a contract with a law firm instead of an individual client. As a tactic to consider, it may surprise you to learn that if a client pays you directly with illegally obtained money, you may have to return the money. From time to time, an attorney will say that their law firm has their own contract or letter of engagement that they want you to sign. Just read through it and suggest any changes you would like. Half the time, they will make any requested changes before you both sign the contract. I combine my contract with my simple fee schedule because I want it known that I will expect to receive payment for specific fees in advance. For example, experts often require payment for deposition and trial testimonial time in advance. However, you will learn that the research and analysis that precedes the writing of an expert report can consume a non-trivial amount of the time and money as well. So I suggest that you consider asking for a replenishment of retainer dollars when and if you reach the point that an attorney asks you to prepare an expert report. Your expert report delivers your opinions, your research, and the bases for your opinions. Rule 26 in the Federal Rules of Civil Procedure requires you to include the information that you considered in reaching your conclusions or opinions. I'll explain in detail what you must know about this rule in Lesson 6, Writing an Expert Report. For now, however, I want you to know that if your expert conclusions do not work well for the attorney, he may decide not to use you any longer as an expert witness. What happens if you did not receive that payment in advance? How likely is it that you'll receive payment now? Why should you even wonder? Ask for advance payment for that significant piece of work, but do not ignore reality. You can ask for advance payments, but sometimes you will have to be pragmatic and work first, and then ask for the money by invoice later. I did that in the earlier parts of my career, and most of the time, the lawyers or their clients did pay. If a case ends poorly for your client, and you did not receive payment in advance for that final testimonial day, you may have a reluctant client or an unhappy law firm. Do you prefer payment in advance or the uncertainty of whether the client will pay you after they hear your testimony and no longer require your services? Sometimes the clients that hire you as an expert have to borrow money to pay an attorney, who then tells the client that they must also hire an expert. You can understand this and you can appreciate the client's plight. However, unless you volunteer your expert witness services, you should still protect yourself by ensuring that they pay you, at least in the form of a starting retainer.